from 13501A and B. That was intentional based upon the legislative history.
Mr. Jensel, is it the state's position that the prosecution has full discretion under Arizona law to charge any minor for any offense after they turn 18?
Well, no, I don't think the state would go that far, and I think Mr. Allred's indication that this is just as absurd as the St. John situation. For one, that's anecdotal evidence that I don't believe is. Well, certainly I'm not going to rely on Mr. Allred's recollection of the procedural aspect of that case, whether it was they didn't go forward because they chose not to or because they were precluded. Again, here we go with anecdotal evidence again. I believe there's evidence in this state for minors under the age of 14 who have been tried for murder, is my recollection, although I frankly looked for cases on that and were unable to find anything published. But the clear distinction between this case, just conceptually, versus the St. John's case, is that we've got a pattern of conduct here that did not stop at age 13. Just happened to be that was the first earliest date. We've got obviously a pattern of behavior starting at age 13, going all the way through age 18 when Mr. Kost was finally apprehended. And the state did not wait to charge Mr. Kost on any of these other than just gathering the information that was steamrolling in 2004.
My question, though, is does the state have unrestricted discretion, though? And I think you indicated no.
Well, unrestricted discretion, based on some of the cases talking about this defense of infancy, whether it's going to apply here or not, certainly there's an indication that any minor under the age of 7 cannot be charged. That's not what we're dealing with here. So that the key age range based on the case law and the application of this defense of infancy that was, according to the cases that are going back several decades now, they're talking about how the defense of infancy was written into the predecessor 13501. That's what Taylor says. That's what Palat says as well. Palat's dealing with the issue, and they decide that the defense of infancy is not going to apply to juvenile proceedings. And it's restricted to cases like this, I suppose, where the state's charging, not like this, the state would charge a minor between the ages of 7 and 14 as an adult, and therefore you have this rebuttable presumption of the defense of infancy. So, the state's not going to agree that any minor under 7, but I think theoretically under the cases that, yes, an adult can be charged, a minor could potentially be charged as an adult between the ages of 7 and 14 with this rebuttable presumption.
And I think you've indicated you're something along the line of making an offer of proof that in the event the court concludes that this defense of infancy applies, that it's your position that you're entitled to a hearing to address that issue and you would have evidence to present.
That's correct.
Let me ask one other thing. 1998, major changes made to juvenile law and the Constitution, some changes in the statute followed thereafter. Under 13501, the legislature spelled out again under 501A certain offenses that the county attorney had to charge, and then in a real sense expanded the county attorney's power to charge a fairly wide variety of other felony offenses at their discretion for juveniles who are over the age of 14. Is it fair to view that grant of power as refraining from granting the power to charge before that age unless it's through the mechanism provided in juvenile court?
You're talking specifically about being under the age of 14.
Right.
I don't think it's fair to cases like this. This is one where the state, I would agree with Mr. Allred that obviously the state is acting improperly. They find out about offenses that are committed by a juvenile when he or she is a juvenile and wait until that person turns 18, with the exception of the court's indication close to the 18th birthday. That happens frequently.
And I'm saying as a limitation of power, under the transfer process, two things have to happen. The prosecutor has to conclude that it's appropriate to exercise their discretion to request a transfer to adult court, and then the court has to agree with that exercise of discretion for those minors under the age of 14. Even as to 13501A, the prosecutor has discretion to charge, but under ARS 13-504, the court, on its own initiative, can send the matter back to juvenile court if the court believes that the transfer was inappropriate. It seems to me that the legislature was trying to address this very delicate issue with a balance of power between two branches of government, not just one.
I wouldn't disagree with Your Honor at all. However, I think just our case is different because we're dealing with a case where the defendant is now 18, he's now an adult. All those policy issues that the court addressed, the state has no qualms with at all, but that's dealing with because you're dealing with juveniles at the time. The state had no option to charge Mr. Kost when he was a juvenile in this case. So
that was the legislature's choice, and the way that's phrased, as I've indicated to both of you, is that attaching criminal liability, that statute, 13501, affirmatively attaches criminal liability to certain offenses at 15 or older and to other offenses at the discretion of the prosecutor from 14 on, but does not address juveniles below that, with the exception of the process provided by the legislature for transferring.
Your Honor, I don't have any clear answers to that particular question at this time. But as the state said, the implications, and unless this court is going to limit it just to based on those issues about the defense of infancy, we're dealing with widespread issues. If this court is going to say that because there was no jurisdiction under Title VIII, because the transfer hearing cannot take place, that's what the state's concern is, that not just for these counts 1 through 4, but if the court's inclined to dismiss, then that, and we can, again, if the court needs us to do more homework on that issue, we certainly intend to. It's probably going to come back with authorities from outside Arizona based on my initial research.
All right. Anything else, Mr. Ellery, in response to those questions?
No, Your Honor.
I would take the issue under advisement if I conclude that presentation of testimony is appropriate. I'll certainly give the parties notice. We can set an appropriate hearing and give the defense notice that we're going to have an evidentiary portion to that hearing. All right. Moving on to the Simpson 2 hearing. Under the applicable law, the state has the burden of proof here. State, ready to proceed with that at this time? Do you have any preliminary opening statement, or need a moment?
Your Honor, the state has no evidence to present this day. I mean, obviously, as the court's aware, we had a Simpson 1 hearing, which was over a couple of days, 2 years ago now, maybe, where testimony has been presented to this court regarding selected victims on that day because they were the offenses the state presented evidence on under the statute that's now been held unconstitutional by the Court of Appeals, at least pending further review. So the state is also, this court is certainly aware of the other cases presented that the state has charged, in addition to those that had been held no bond pursuant to the statute. We have 30 total charges. We have 13 listed victims. Frankly, there's other behavior that the state could cite as far as the defendant's behavior online, in particular, as related to other underage females who are not listed victims. But the state would argue that since the court is going to go forward today, the state would argue that a significant bond is appropriate in this case. The state would ask for $500,000. The defendant is in a position similar to, as far as the length of prison time, similar to a defendant who was charged with first-degree murder, non-capital. Certainly, as Mr. Allen himself pointed out, counts 1 through 4 are up to 50 years in prison on those. Counts 5 through 8 are similar. I mean, Mr. Kost, if he's found guilty of any significant portion of the charges in this case, is looking at a lifetime in prison. With that creates an inherent risk of flee because of the length of time. there's also evidence in this case that Mr. Kost is a danger to the specific victims in this case, based on his behavior towards those victims in this case. The state is not going to say that Mr. Kost was out there violating neighborhoods, he's not breaking into houses. All of these relationships all of these offenses that are charged against Mr. Kost, in which he clearly demonstrates behavior that he does not understand the word no in regards to sexual behaviors with these victims and other individuals, even not named victims in this case. So the state is concerned about how to best prevent Mr. Kost from engaging in the same types of behavior that led to these charges in the first place. There's certainly evidence in this case that he used Facebook and text messaging to coerce, to manipulate, to exacerbate his behavior towards the victims that he would eventually sexually offend against in person. So the state's going to ask for a high bond. If in the event that the defendant makes bond or the court releases him otherwise without a bond, the state would ask for electronic monitoring. I believe the defense agrees with that. But the state would ask for pretrial services, release, and supervision. Logistically how that's going to work out, I think there's some question with probation as to how that would happen. But Mr. Kost should not have any internet access, shouldn't be allowed access to a cell phone, should not be allowed to contact any of the victims in this case or any of the state's witnesses in this case. And that at a minimum, Mr. Kost's behavior, as the state will concede, was not to the general public. He's not out like others, especially those indicated in the Court of Appeals case from Simpson 2. He's conceptually different. However, Mr. Kost is a risk to females his age or younger with whom he has contact. And so the state would ask that Mr. Kost certainly not have any contact with any minor females under the age of 18. But his release also poses at least a risk in the minds of the victims in this case. The victims in this case have been, some of them have been here at prior hearings and have expressed to us their concern about Mr. Kost being released. And that their input should be taken into consideration as well. Oh, Your Honor, the state would ask for a cash bond, not a security.
All right, Mr. Allen.
Your Honor, first I just want to address what burden the state has based upon Simpson 2. It's very specifically laid out in that court case. In that court case, it says that the state bears the burden and the court must find that there is clear and convincing evidence that the defendant poses a substantial danger to another person or the community, and that no condition or combination of conditions may be imposed that will reasonably assure the safety of the other person or the community. The state just presented no evidence to this court. The state is essentially conceding they cannot meet this burden because they can't. The only thing that the state just referenced was the Simpson 1 hearing that happened about 2 years ago. That was a 2-day hearing. I was present, Your Honor was present, a different prosecutor was present, but the court recalls the evidence that was presented then. This court has also presided over this case for the last year and a half or so, coming up on 2 years. And this case is dramatically different based on the allegations that were presented at the Simpson 1 hearing versus what the defense has uncovered here today. Drastically different. There has been significant evidence uncovered by the defense that suggests that there was a conspiracy amongst many of the girls to lie, a conspiracy amongst the girls to try to trick Tyler into doing something so that they could take revenge upon him. Other significant issues with credibility based upon the girls' own words, their own messages on social media. And then, as recently as this week, the defense uncovered...
I'm going to object this one. Can we approach on this issue?
Yes. outside the courtroom. Is your client willing to waive his presence?
Could we go back with him, Your Honor, or do we need to?
Do you want him to back to be back?
Is it possible? I guess, is it possible or is it not possible? The first question.
It would be my preference not, but I know Mr. Kost has obviously a very profound interest in these proceedings and the right to participate in them. Are you... I'm trying to see if there's someplace here, particularly with duties conferences. I believe we do it over there without... All right, we were back on the record. We had a conference on the record. Mr. Ballard, you were saying?
Your Honor, what the state is relying on here today is the evidence that they presented during the Simpson 1 hearing approximately 2 years ago. 2 years ago, we didn't know what we know here today. In the last couple of weeks, we interviewed Detective Carnes' direct supervisor. And during that interview, Detective Carnes' direct supervisor indicated that Detective Carnes, the case agent, the detective who conducted the vast majority of the investigation in this case and interviewed the vast majority of the alleged victims in this case, violated just about every single Pinal County Sheriff's Office policy during his forensic interviews of the alleged victims. According to his sergeant, PCSO policy is that an alleged victim is to be pointed over to Family Advocacy Center, where a forensic interview is to be conducted by a professional, where it is audio and video recorded. Instead, Detective Carnes went to Boston High School, pulled alleged victims out of class, and interviewed them there at the school. He violated the policy that he's supposed to contact the parents of juvenile alleged victims prior to interviewing them. He didn't even bother. He violated the policy that he is not allowed to interview that many alleged victims all in the same day, which he violated. He failed to draft reports regarding those interviews in a timely fashion and had to be reprimanded and forced to write reports on his interviews with the alleged victims. He did not video record his interviews with the alleged victims, and he violated the chain of command. All of the evidence in this case, the only evidence in this case, are stories. Stories of these alleged victims. When all your evidence is allegation and stories, and there's zero forensic evidence to support any of it, the forensic interview becomes exponentially more critical to be done properly, especially when you're dealing with an alleged child victim. There are very specific protocols that a detective must follow during a forensic interview. And Detective Carnes, the case agent in this investigation, violated every policy in the book. And that was not presented during the Simpson 1 hearing. As a matter of fact, Detective Snyder, who took over for Detective Carnes, after Detective Carnes had been yanked from the case, relegated to patrol and desk duty, I asked Detective Snyder on the stand, why did you take over this investigation for Detective Carnes? And he said, it was simply because Detective Snyder had more experience. I asked him directly, did Detective Carnes do anything wrong? And he said no. That is blatantly not true. Detective Carnes violated every policy in the book, was yanked off the case, letters of reprimand went into his file, and Detective Snyder took over. That's what was presented to this court 2 years ago in the Simpson 1 hearing, and this is what we know now. That's why the state can't meet its burden. One of the many reasons why the state can't meet its burden, that Tyler is a substantial danger to any person or the community. In addition to that, it was also not presented during the Simpson 1 hearing approximately 2 years ago that Detective Carnes has since been terminated from the Pinal County Sheriff's Office altogether, based upon an internal investigation where he lied to the internal investigator. It was not presented to this court that on October of 2014, nearly 2 years ago, Sheriff Paul Badu himself sustained the allegations against Jason Carnes and recommended his termination. That has never been told to the defense. We found that out this week after a very long-standing public records request. That information is critical. It goes directly to the credibility, the honesty, the truthfulness, the veracity of the very case agent that did the investigation in this case, which is the only basis for these charges in the first place. Given the Facebook conspiracy that's been uncovered, the other social media that directly contradicts the victim's allegations, Detective Carnes' untruthfulness, the letters of reprimand that he's received in this case for his conduct during these interviews, the state cannot meet its burden, and release conditions are absolutely appropriate. While I disagree with everything that the state just said regarding what the release conditions should be as far as a bond amount goes, we agree that there are release conditions that are appropriate in this case and, quite frankly, are required by statute. Under Chapter 14, electronic monitoring is required. The defense has no issue with that. But to suggest that did he say $500,000 bond or $200,000? I'm not sure what he said. Cash bond would be appropriate in this case is inappropriate. Tyler's a kid. When he was arrested in this case, he was a couple months past his 18th birthday. He was in his final semester as a high school student. He doesn't have any money. He doesn't have any assets of his own. A $500,000 cash bond for an 18-year-old kid with nothing, who was plucked out of high school and thrown in jail for the last 2 years, is the equivalent of a no-bond status. And on that point, Your Honor, Justice Bales from the Arizona Supreme Court has recently issued a administrative order discussing the fact that extraordinarily high bonds should not be imposed that would be the equivalent of a no-bond status, which is what the state's asking for here. Tyler's not a flight risk. Tyler has very deep roots to this community. All it takes is looking over here on this side of the courtroom to see the community support and the family support that Tyler has. Does the state really think that this entire side of the courtroom is going to get up and run out of the country? Of course not. His parents and his family have been here for every single hearing throughout this entire case, supporting him. And they will continue to do so upon his release because the defense intends on clearing his name at the end of this. He is not a substantial danger to the community. I attached exhibits to my motion outlining his report cards. He was an A and B student, National Honor Society. He had a scholarship to a small college in Wisconsin. He was a baseball player. He was a volunteer umpire. And there must be about 30 character letters in this packet of family members, friends, members of the community, people coming forward, signing their names to letters for the court to review, vouching that Tyler is an extraordinarily good kid, and that he will absolutely adhere to any release conditions that this court imposes. Given the change in this case from the evidence that was presented 2 years ago during the Simpson 1 hearing to what we know now at this hearing today, the state has not met its burden and cannot meet its burden. And the original bond that was put in place of a $250,000 secured appearance bond on those accounts that were not non-bondable is also inappropriate, given what we know now, because it was imposed at a time when things were much, much different. We would ask that the court issue release conditions in this case, remove the no bond status, and that he be released to electronic monitoring, that he obviously have no contact with the alleged victims, which is not an issue at all. And any other release conditions that the court feels is appropriate is completely fine, as long as it's not a bond in the amount that is going to be the equivalent of a no bond status. Release conditions such as that are appropriate in this case based on everything that we know today that we didn't know 2 years ago, or at least the defense didn't know 2 years ago. Thank you.
State's response.
Well, Your Honor, let me start with just the Detective Carnes, which was vastly overstated from Mr. Alvarez's perspective. Without going into all the details, Your Honor has all the forensic interviews that were conducted by Detective Carnes and others. And the fact that Detective Carnes, which Mr. Alvarez failed to acknowledge, that Detective Carnes had gone through the forensic interview training, the 8-hour and the 40-hour, which pursuant to the Pinal County protocols, law enforcement agents who have the required training are enabled to conduct forensic interviews with victims pursuant to protocols. And yes, the ideal situation is to have those interviews videotaped, and some of those did not occur in this case. Some of them occurred telephonically initially because the victim was out of state. Some of them did occur at Kost High School, and partially because of the rapid nature in which these potential victims at that point were uncovered. The state's not going to disagree that ideally they should have been videotaped. However, the protocols, as this court is aware, having presided over many child sex cases, the primary justification for those protocols and specific issues as to how forensic interviews are conducted is to avoid suggestivity to the minors. And granted, most of these minors were either adults at the time or 15, 16, 17 years old, so we're not dealing with a lot of the issues of suggestivity as to very young children. But the court, you're in a position, Your Honor, to evaluate Detective Carnes' interview style and protocols that he followed during the interviews themselves. So I'll just leave that to Your Honor. You can evaluate whether Detective Carnes' particular interviews had any suggested impact on the victims, because that's the key issue here regarding anything regarding Detective Carnes, whether Detective Carnes' interviews somehow tainted the victim's disclosure during those interviews. I believe when Your Honor listens to those interviews, that is not the conclusion that Your Honor will come to. And, Mr. Allard mentions this conspiracy again, on the courthouse steps way back when the defense said that those are conspiracy for all the victims to, make this up against Tyler because he's just a player and those kind of things. I mean, the evidence that this court has is a far different impression of Mr. Kost, and he's just a misunderstood player. He's a manipulative, coercive, very intelligent young man at the time that he was performing these offenses, who was willfully deaf and blind to the word no in regards to these victims when they would object to his sexual advances. And that is clear from the evidence that Your Honor has. It's also clear from other computer evidence that Mr. Allard doesn't want to mention. He says they're just stories. There's also evidence from Mr. Kost's computer, which this court does not have yet, which will shed light on this issue of Mr. Kost just being misunderstood and the victim of a conspiracy. So this case is much more than just stories. However, there are 13 different victims who disclose specific sexual offenses committed by Mr. Kost, and I don't think this court should rest easy with the fact that he's going to go back home to his parents, because some of these offenses were committed right under their nose. Even with agreements from his parents, with the parents of some of these victims that they would be supervised while they were in his house, and that didn't occur. And that's when some of these offenses occurred, is when his parents were either supposed to be home or were home and were watching and supervising Mr. Kost and some of the alleged victims at the time. So I don't believe that this family support, particularly his parents who allowed some of these offenses to happen based on their negligence at least. So the state will renew its insistence that a $500,000 cash bond is appropriate, considering the number of the offenses and the potential prison range which Mr. Kost faces, and puts him in a similar position to others facing similar charges, where it's a lifetime in prison and creates that risk to flee simply because of the nature of itself. And there are cases in this court where defendants had fled who were facing similar time. It just creates that risk. And for that reason, for all those other things that the state has asked for, no internet access should be given. That's going to be difficult to monitor from probation. I understand that he should not be allowed internet access because of the nature of a lot of the build-up and aspects to some of the offenses which this court is aware of. He shouldn't have a cell phone. He shouldn't be allowed internet access. If he's in electronic monitoring, which the defense has already agreed.
All right. The court finds that the state has not proved by clear and convincing evidence that the defendant poses a substantial danger to another person in the community, and that no condition or combination of conditions of release may be imposed that will reasonably assure the safety of the person or the community. Therefore, given the current state of the law, the defendant is bondable. Parties have each addressed the amount. I have some other questions, though, that bear on these issues. We have 3 separate cases. We have a bond set, I believe it's in 2014-01-772, of $250,000. The minute entry references combined, and I think the reference was, as one of you indicated, to cover those counts in 2014-00949 and 2014-01054 that were not held non-binding. My issue that I want to cover on the record here is there has been no motion for release on the case where the bond of $250,000 is set, and it's a bit muddied by the fact that it's referenced to combined here. My understanding, though, is that the state has given notice that release issues were at stake, or...
Yes, Your Honor. To the best of its ability, we contacted or made attempts to contact all the victims in this case to indicate to them specifically that the release issues were going to be addressed today.
So there is...
I believe that the state has not received confirmation back from all the victims, but I believe that we have met our obligation under the Victims' Bill of Rights. My point is there's no restriction on the court because of victims' rights at this point to prevent the court from addressing release conditions as to all 3 cases. No.
All right. And obviously in 2014-00949, we have a major motion pending for oral argument on August 4. Currently, though, all those counts are combined. It's my position that the court can consider that in deciding what the appropriate bond is. I know you've covered it to some extent, but now that I have indicated that the offenses in 2014-00949 and 2014-0154 are subject to bond and release conditions, I know there's been reference to the state $500,000, but we have 3 cases here, and so I'm not clear what your position is, and I'm not aware of any practice where one bond would cover 3 cases. But
I guess the state's proposal then would be, we would recommend a $500,000 cash bond on each of the 3 cases to run concurrent with each other, or a $500,000 bond on 949, and a lot of the other stuff, however the court wants to do it.
Well, I have not done that before. makes sense somewhat, I suppose. It doesn't fit neatly into the rules of procedure, but you're saying to impose one bond that covers all three cases?
That would be a safe suggestion.
Mr. Ogden?
If the court is inclined to impose a bond at all, I think that it is well within the court's discretion to make it apply to all three cases as a lump sum. I believe that has occurred in other cases that we've handled. That being said, I don't believe a bond in this case is appropriate, given everything that we just discussed. Although there are release conditions aside from a bond amount that are appropriate and required by statute, which is the electronic monitoring. We have no issues with no contact with the alleged victim. We don't have an issue with no internet. So there's a lot of the release conditions that the state is discussing that we would have no problem with in this case.
The state phrased it as inherent flight risk. Why isn't there an inherent flight risk still that would mandate a bond of significance here?
And if the court may recall just from the record, because I know that this court wasn't presiding over the case at the early stages, but there were initial charges. There was a bond given. Tyler was released. Then there was additional communication with the detectives, and then he was rearrested. Both in the first arrest as well as the second arrest, we arranged for a self-surrender with the detectives. He had undersigned counsel, and we were in communication the entire time. So there's no suggestion or basis to believe that he would be a flight risk now, considering he had us as counsel at the very beginning, and on both occasions when there was a warrant, we arranged a self-surrender, and he essentially turned himself in. So there's no basis in the record of his behavior that would suggest that he's a flight risk. Aside from that, I think that his ties to Arizona are significant, given all of the community and family support that he has here. All of the other factors that would be appropriate for the court to consider in deciding whether someone is a flight risk weigh in favor of no bond or a low bond. The other issue, quite frankly, Your Honor, is that although the state talks about the amount of prison time at the end of this being an inherent flight risk, based on the revelations in this case, a prison term, the lengths of which the state has just discussed, is highly unlikely in this case. There's no reason to believe that Tyler, who has no money, no assets, no history of failing to appear, no criminal history of any kind whatsoever, and all of this community support and all of these ties to Arizona is a flight risk in any way, shape, or form. And electronic monitoring, quite frankly, would take care of any issue with the probation department or the state wanting to know his whereabouts at any given time.
State, you want to respond to that?
Nothing else, sir.
The other question I had, in the event that the Court of Appeals grants the motion to stay, counsel have any comment on the procedures that should follow at that point? My thought is perhaps to include an order of automatic surrender within a time period.
I can't think of another suggestion, Your Honor, so yes, the state would agree. The defense would agree with that as well, with the understanding that given all of the new information that has come up since the Simpson 1 was held and a finding was made by the court that proof was evident, presumption great, that crimes were even committed, that upon a self-surrender in this case, that we would be immediately requesting and asking that a Simpson 1 hearing be set so that we can address that finding that the court still must make as to whether still a bond is appropriate, even notwithstanding Simpson 2.
All right, I'm going to set a bond. I believe that there is an inherent flight risk here, given the number of charges, the fact that they're currently combined. This is an evolving situation. We have a major motion pending. The complexion of the case obviously can change, but at this point, I believe it's appropriate to set a substantial bond. Given the exposure here, I'm going to set a bond of $100,000, all combined for all three cases. In addition, I will be issuing specific orders regarding his conditions of release that will include no contact with the victims, no contact with witnesses, no contact, precluding him from having access to the internet or using any cell phone or electronic means of communication. Also, I will include a self-surrender provision. I'm going to need some time. I'm going to work on the specific language of these conditions of release. I'm just stating on the record to give you some general idea what areas will be covered. There will be GPS monitoring. It is going to be full-scale GPS monitoring 24 hours per day. I'm considering also restrictions on essentially a house arrest or something akin to that. Either council wish to address that, and application of GPS on this. Obviously, provision would be made for him to go to and from doctor's appointments that are legitimate, to see his attorney for legitimate purposes, and to come to court, obviously. Any suggestions along that line?
Your Honor, the state would agree with that if probation is able to conduct that. I don't want the answer to that question.
Your Honor, good morning. Adam Shore with Adult Probation. After speaking with Lisa Penny with GPS Solutions Monitoring, there are going to need to be some significant parameters that we are setting to include whether there will be a curfew and as far as where the defendant will be allowed to go as far as perimeters. Will he be able to leave Pinal County? Will he need to stay within the city limits? Will he be able to leave the state? There are certain exclusion zones that they do require. Some of those zones would be airports, train stations, Greyhound stations, playgrounds.
When you say they require, you mean the GPS provider?
Yes. These are the things that they will need to know. Whether he's excluded from playgrounds, schools, etc. They will need to know if he's allowed to attend church, NA or AA meetings, or any other corporate programs. And lastly, will he be allowed to work? If we have answers to all of those things, they can appropriately, along with pretrial services, monitor his progress on pretrial services.
It's my understanding that with house arrest and limitation, that pretrial services will be able to monitor any exceptions to the house arrest, such as going to see his attorney, see a doctor. Is that correct?
Yes, that's correct. So those things will all be notated. GPS monitoring solutions will have all of those as well. And so as they track them and as we track them, reports will be had and be submitted, and we will be notified of anything outside of those parameters.
Yes.
Again, I understand the court's concern and the logistical concerns for the probation department. I guess our suggestion on this would be, if possible, the restrictions to some degree that the court has envisioned. We would request something more akin to a curfew type home detention, almost like court release, to allow Mr. Kost to freely confer with counsel. You certainly would need to check in with medical staff at this point. Our goal would certainly be for him to be able to continue education and to get employment. So those would all be things that are traditionally covered under a home arrest type setting where a person essentially is allowed to check in and out like work release in a jail facility. I think there are always logistical issues and concerns that are presented there, but at the same time I think that is something that's very achievable and worked through on a daily basis with courts and GPS monitoring. It's done almost all over the state now. So we would request that he at least have that to continue, so he's not just sitting at home giving everybody concern about what he's doing.
Well, I don't know if the state wants to respond to that request.
The state would object to that question.
I'm inclined, at least at this point, to keep him on house arrest, essentially, with provision for him to be able to go see his attorneys and see doctors and, of course, come to court. Does he have a passport?
He does not, Your Honor.
I will also issue an order restricting him from having access, possession of any firearms or deadly weapons, standard type condition along that line. As far as monitoring internet access, I know you expressed questions about the difficulty of doing that. Are you aware of any capability to meaningfully monitor that in today's world where there are so many devices that have access to internet? I'm not.
Not specifically, Your Honor.
I will certainly issue an order that he's not to use it. But as far as monitoring, and I don't know if pretrial services can weigh in on that or not.
Your Honor, are you referencing as far as monitoring him himself while he's at home and his progress? Is that what we're referring to?
No, I'm saying whether he's actually accessing the computer, whether there was some capability of monitoring him. But devices that have access to the internet are so common now that it would be difficult to do, it seems to me. But are you aware of anything?
I am not.
Okay. All right. All right, I'll be spelling out the specific conditions of release in the minute entry. I've given you kind of areas that will be included, but not specific language. Is there anything else requested?
Is the $100,000 cash or security?
Cash.
Your Honor, if we could on that point, a $100,000 cash bond for this young man and his family is essentially a no bond status. That is an incredibly massive amount for a family of modest means to post in this case. A secured appearance bond would be more than appropriate, given that it's still a significant financial amount that's paid through a bondsman up front. And then collateral that is on the hook in a significant amount of $100,000 would have to be held by the bond company. That is more than sufficient, given the modest means of an 18-year-old who was plucked out of high school and put in jail for the last 2 years, having zero assets of his own, zero ability to make any money, considering the court's not even going to allow a curfew for it to work. And then, obviously, the modest means of the family here in this case. And I would, again, like to raise the administrative order by Justice Bales, which specifically talks about bonds that are so significantly high that they are essentially a no-bond status. I mean, this is, in some ways, more significant than a $250,000 secured appearance bond because it takes $75,000 additional cash to be able to even meet it. So, Your Honor, if Your Honor is inclined for a cash bond, I would ask that the court reconsider it being $100,000 and something lower. Otherwise, we would strongly urge the court to consider a secured appearance bond, which would be more than sufficient, especially considering the GPS and all of the other conditions that we've agreed to here today.
I may be applying the incorrect label here. On occasion, historically in this court, we have taken collateral, and that is what I did not want to do. I want, if it's through a bonding company with a down payment, I don't have a problem with that. So a secured appearance bond. I do not want to open the door to the family submitting what they believe is collateral to the court directly as security because of issues that obviously creates.
So, of course not, Your Honor. So if it's a secured appearance bond, they would go through a bondsman, and of course the bondsman would be posting the $100,000 cash. So as long as we're in agreement on that, then
Understood.
thank you, Your Honor.
Your Honor, in regards to the GPS monitoring system, typically clients would go to them, but if it's court ordered, they would like that system installed prior to release.
This is a condition of release, so Mr. Kost will have to be fitted with the GPS monitoring before he's allowed to leave custody.
Do we have an estimate on the timing of that? Because I don't know.
Yeah, I've been in contact with her as of late last night, and she is and can be here as soon as we get her the bill. So she can be here today. She can be here within an hour. She's in Casa Grande. She's willing to be here literally all of those things that you can do.
If the responsive over the weekend should bond be posted or is only during weekdays?
That's a great question. I can find that out right now.
And Your Honor, I know we had another issue that we wanted to raise with the court. I don't know if this is a good time. If we've been
I have
having
an issue as well, so...
Is it possible to have a short break before we do that, unless the court's not through addressing this issue?
Yes, the issue I have is a scheduling issue with the date for that oral argument. I want to revisit that with the parties and that may take some turning back and forth, or perhaps we can meet in chambers to address that. But then you want to come back on the record after
Right.
that? I think we'd all use a break, so all right, let's do this. All right, Mr. Kost is present. We're back on the record, and all three cause members with all counsel present. As I mentioned in chambers, I fear I'm going to have some scheduling issues with the oral argument on the pending motion to consolidate and motion to sever. It's currently set for August 4, and in speaking to counsel, it's my understanding that rescheduling will not present a great inconvenience to either side. Is that right?
That's right, Judge.
All right, and I think parties are going to be more efficient to just have that scheduled through my judicial assistant than try and work through four attorneys and the judge's schedule here today. So I'll direct that the parties confer with my judicial assistant in the following week to reschedule that for a time that is mutually convenient to all of us. And just time parameters on that, I know we've discussed that before. Is anything changed in regard on that motion?
Not as far as time records go.
All right, and I think, Mr. Hamby, did you indicate there was another issue you wanted to raise on the record?
Yes, Your Honor. We're just requesting the court's assistance with orders regarding the ongoing discovery issues, particularly with regards to things that we discussed, at least at some issue today, regarding Detective Carnes. Through our own requests, we eventually received documentation that is substantially different than that was provided to us yesterday by the county attorney's office. We would ask the court to enter an order to the county attorney's office and the Pinal County Sheriff's Office to immediately turn over the complete and unredacted documentation and any information, including reportings regarding the investigation into former Detective Jason Carnes, his separation from it to be Brady material and that we do not have to request it, but we are requesting it, and we are asking the court to enter an order that be done by a date certain. And the date certain we are requesting is very, very soon. We would like it a week from today, no later than.
Mr. McBride, Mr. Jensfold, what's your position on the oral request here today?
Yeah, the state would ask for time to respond. I mean, there are more issues that arise as a result of this request, particularly in an unredacted form. The state would request a 10 days to respond based on this motion.
I'm inclined to give the state the opportunity to respond in writing. My question is, might we all be better off if the defense reduced its request to writing as well, so the issues were framed?
We'll be happy to put a request in writing, Your Honor. I will say, by putting our request in writing, in no way, shape, or form do we waive or excuse the state's obligation to provide disclosure under Brady.
The state has disclosure obligations both by rule and by Constitution, and certainly nothing about the court allowing the state time to file a response changes that. There is affirmative duty on the part of the state to make timely disclosure. So, with that clarification, though, I'll order that the defense reduce their request to a written motion, and the state will have the normal time to respond to that. Anything else we need to address today?
Last issue, Your Honor, just on the court's order. I know we had a chance to speak with a probation officer here today. He indicated, I think, that one thing that needed to be included was a phone number, a contact phone number in the court's order, and I think he'll provide that to the court. We're asking, if it can't be done here in the courtroom, the time period, and whether or not there's any other issues we need to hammer out for a release order so the family can do everything they can to get a bond posted.
You're asking, I intend to have the specific orders drafted by early this afternoon, is my hope. But you're asking for...
Is it okay if the family, if possible, then starts the mechanics to have something so that the clerk's office is on notice, so that if they're able to get that secured bond posted, that can be done immediately, so there's no holdup. Let's say the court is able to finalize that order. I'll make up a number, Judge. I say 2:30, and then the family receives the order. Then it goes to then the clerk receives the order, and then by the time anything can be done, it's after 5. Can the court at least let the clerk of the court know that the family is allowed to post a secured appearance bond of $100,000, and then that can start the release process pending the court finishing that order today?
Yeah, there's no problem with that. Just that will be one of the conditions of his release, to post the secured appearance bond. And then, obviously, I think it's going to take some time to coordinate with the GPS provider to be here in the event that bond is posted, and arrange for him to be monitored. Okay. All right, anything further?
No, you're right.
Let's take a recess.